Welcome back. In this lesson, we are going to talk about probate. The hope is, by the end, you'll understand what probate is and what it can do and why it exists. Second, you'll learn what makes probate simpler or harder. And finally, you'll take a small step that makes your plan easier to carry out later by capturing a few key facts your future executor could use to speed the process along. For many people, probate is one of those words that just sounds intimidating. You may have heard it's long, expensive, and something you should avoid at all costs. But here's a more useful way to see it. Probate may be a legal bridge. It's a structured way to move ownership from one person to the next, across a moment that could otherwise feel like a chasm, so the transfer happens with clarity and legitimacy. If you rewind the clock to medieval times, this makes more sense. Picture a castle. The lord of the castle dies. Everyone immediately has the same question. Okay, who owns the castle now? Back then, the answer could involve literal battles, people fighting over land, titles, and control. These days, we've decided we prefer paperwork to swords. So society created a process that can confirm authority, settle valid claims, and transfer ownership without chaos or bloodshed. That's the spirit of probate, not a punishment, more like an organized handoff, so the next owner can hold the keys with a clear right to do so. So, what should you expect during this process? At its most basic level, the probate process involves 4 foundational steps. First, the court helps identify and document all the property you own. This is where your hard work of listing your assets in the MyEstateKit app pays off. Second, those assets are preserved and protected while the process moves forward. Third, the estate pays any debts you owe, including funeral expenses and taxes. And finally, the remaining assets are transferred to your beneficiaries. This work is led by a person you name in your will called a personal representative, also known as an executor. If you don't have a will, the court may appoint an administrator to take on this role. This person receives a legal document, often called letters testamentary or letters of administration, which gives them the official authority to talk to your bank, sell your property, and carry out your instructions. Or if you died without a will, then the instructions of the state. It is important to be realistic about what this process looks like. Because it involves the court and legal notices, it is rarely a fast process. In many states, the law requires assets to stay in the estate for a minimum period, often 6 months or more, so that creditors have time to make their claims. An uncontested estate might move through the system in 6 to 12 months, but complicated situations could take longer. For example, a creditor might say the person who died, the decedent, owed them money, and a court may need to confirm whether that claim is valid. Or someone might argue the will didn't reflect the decedent's real wishes and try to contest the will. That kind of challenge often shows up when people feel surprised or unhappy about what they did or didn't receive. The practical takeaway is to take some time to think through these situations and ensure you have done all you can to create a thorough estate plan, which may include talking to beneficiaries, ensuring that your will is valid, and listing all your information in a clear and easy to access way for your personal representative. Probate is also a public process. Because the court is involved, your will and the inventory of your assets could become part of the public record. This is one of the reasons some people choose tools like trusts to keep their affairs private. There are also costs involved, such as court filing fees, personal representative fees, and often attorney fees. In some states, these costs are calculated as a small percentage of the total value of the estate. So what could make probate easier? A few things commonly help. A clear will may reduce the number of choices the court has to make. Naming a capable personal representative and a backup may prevent delays. And having an organized asset list may keep the representative from spending months trying to track everything down. Now, what could make probate harder? There are a few, including not having a valid will, not having an organized list of all your assets and liabilities, and complications if there's a question about what you wrote in your will, where you legally lived, or where your real estate sits. If there is a question about where do you live, there are a few things you can look at: your driver's license, voter registration, taxes, and where you consider your permanent home. These may all matter, but if there is a concern, discuss it with a professional advisor. And don't forget that owning real estate in multiple states could create the need for more than one probate process. Ancillary probate, which is just a fancy way of saying additional, would involve additional courts, additional steps, and additional cost. That's why it's so useful to list not just what you own, but where it is. Here's the gentle perspective shift for today. Probate often gets painted as a villain, but probate could also be seen as a system with a purpose. It may help create clean ownership and close out claims. For example, many states have deadlines, often tied to notice and filing steps, where a creditor's ability to pursue the estate may be limited after a certain window passes. In plain language, once an estate is properly opened and closed, the legal system may treat many claims as time-barred, which can help protect beneficiaries from surprise bills that show up long after assets have been distributed. On the flip side, if an estate process never gets properly started, a creditor might argue they never had a fair chance to assert a claim, and that could create more uncertainty for beneficiaries later. The question isn't, is probate good or bad? The more useful question is, if probate happens, have I made the starting point clear and efficient? Having watched the video, you now understand that probate is a structured path to closure, not a mysterious legal trap. You know the steps, you know the roles, and you know that your plan is the guide for the entire process. For those who want to go deeper, you can review the state-by-state probate guide in the resource section to understand different probate options that might exist in your state, such as a simplified or summary probate, which many states now offer for smaller estates. In our next lesson, we'll look at what the role of the executor is in the probate process and get an overview of estate administration.